Well, the Eighth Circuit Court of Appeals just issued an opinion that could be entitled, "Not Today, Satan." Tony DeWitt here, Missouri appellate attorney, a guy who likes to make the law make sense on YouTube. Today I get to make some sense out of the law of Minnesota. And I also get a chance to expound on a couple of the rules of civil procedure that have come up in this particular case. When someone files a case and it gets lodged in the federal system, a couple of things happened, one of which is that a series of orders get issued about how the case is going to move forward. When that happens, the court also will come in and issue a scheduling order. And what it will say is, if you're going to file a motion to dismiss, you need to do it by this date. If you're not going to, your answer has to be in by this date, assuming that somebody hasn't already answered at that point. And then it sets deadlines for things like the time for a motion to amend to be filed. And it will also set deadlines for pretrial conferences and mediation if possible, that sort of thing. Once it does that, then those deadlines are sort of hardwired into the case, and the only way you get around them is to go in and show just cause for why you shouldn't have to comply with those rules. There is also a rule in the Federal Rules of Civil Procedure called Rule 11. And what Rule 11 does is it says, okay, you have to turn square corners with the other lawyers in the case and also with the court. So you have to do certain things that are absolutely by the book. One of them is if you file a pleading that is false or fraudulent or that is frivolous and you know that it's frivolous, well, then you can be sanctioned and we can award attorney's fees against you. We can essentially strike your pleadings and render judgment for the other guy. So there are lots of things that a court can do to make people behave. They shouldn't have to make people behave, but they do. And that's because when you get people with big egos in a courtroom, a lot of times emotion gets the better of them and they say and do things that they know they shouldn't do. But that's just sort of the nature of the beast when you have very smart people, but also very emotional people. Another thing that's going to come up in this case is res judicata. Res judicata means the thing has been decided. Res, the thing, judicata has been decided. Res judicata is a doctrine that says once an issue has been decided by a court, you can't bring it back up again. So if I go and I sue the people who are burning trees in my neighborhood here for nuisance, and the court says, no, it's not a nuisance, I can't come back on the same facts and file the same lawsuit against the same defendants again, because that has already been decided. Every lawyer who's passed the bar understands that. That doesn't necessarily always mean that every lawyer is going to abide by that rule. And then finally, another thing that's important in this case is how magistrate judges, district court judges, and the Court of Appeals work together. Some of you may be aware, I did a video several months ago about how federal courts were organized and how they have magistrate judges. Magistrate judges are not appointed by the president. They're not confirmed by the Senate. Magistrate judges are judges who are appointed basically by a vote of all of the district court judges in their district. So those judges get together and say, hey, we really like Billy Bob over there. We think he's a great lawyer. I bet he'd be a great magistrate. So they appoint this magistrate and they cloak him with some judicial authority. Now that judicial authority derives directly from the district court. He does not have any judicial authority under Article 3, absent the fact that he has an Article 3 judge that he reports to. When he is cloaked with this judicial authority and he starts making rulings, one of the things that happens from time to time is people go, that ain't right. And so they will take it up and they will appeal it to the district court. So the district court looks at what the magistrate wrote and says, well, I either agree or I disagree. And if I agree, then I issue an order affirming the district court or the magistrate's judgment. And if I don't agree, then I overrule it and I decide that particular motion in the way that I think it should be decided as the district court judge. Now, if I get it wrong as the district court judge, your right to appeal goes to the Court of Appeals. And usually that right of appeal doesn't happen until the end of the case, but you do get a right of appeal. Anything that affects your substantive rights during the course of a case, you can appeal later on, assuming that you are aggrieved by that bad decision or what you perceive to be a bad decision. In this case, the Satanic Temple got hurt feelings because they allowed a monument to be put up that had Christian leanings, and they wanted to put up one honoring their leader. At any rate, the city of Belle Plaine decided that they weren't going to do that, and so they got sued. And we'll take a look here at what happened in the court, and then I will have some comments at the end. This is an appeal from the District of Minnesota. It's in the 8th Circuit Court of Appeals, and it's in front of one of the judges that I used to work with, Dwayne Benton, along with Colleton and Smith. Judge Colleton wrote the opinion. Basically, the Satanic Temple filed a lawsuit against the city of Belle Plaine. And they said, look, you opened up a public forum for a Christian monument, but you closed the forum to exclude a satanic monument. The temple alleged violations of state and federal constitutions, as well as a breach of contract and promissory estoppel. So both parties moved for judgment on the pleadings. And on July 31st, 2020, the district court granted the city's motion in part and dismissed 9 of the temple's 10 counts without prejudice for failure to state a claim. The court permitted the temple's promissory estoppel claim to proceed. On December 1st, after the district court's deadline to amend the pleadings, the temple moved to amend its complaint, and it wanted to reassert its previously dismissed constitutional claims based on the free exercise, free speech, and equal protection clauses. And they also sought to add new counts for violations of the Establishment Clause and the Due Process Clause. On January 26, 2021, a magistrate judge denied the temple's motion, saying, hey, you failed to show good cause to amend after the deadline. And even if you had made it before the deadline, your proposed amendments are futile on these reasserted constitutional claims. When a court relies on the doctrine of futility, basically what it says is, if I allowed you to amend the petition and put this into the complaint and say, this is your claim, I would just have to dismiss it later on because it doesn't state a claim. So your amendment is futile. And much like, resistance in the Borg, you don't have anywhere to go with it. And it would be inappropriate to allow the temple to assert new constitutional claims at this late stage in the litigation. So the magistrate judge also denied the temple's request to voluntarily dismiss its case and reassert its constitutional claims in a second lawsuit. The judge concluded that the city would in fact be severely prejudiced if they were allowed to do that. So before objecting to the magistrate judge's order, the temple filed a second lawsuit in the district court on February 4th. And I didn't make this clear earlier, but in order to appeal it to the district court, what you have to do is you have to object or take exception to the ruling of the magistrate in order to let the district court know that you want the district court to review the magistrate's order. And so they did this without taking that step. In other words, letting the court know that they weren't happy with the ruling. That complaint acknowledged that its core factual allegations were the same as those underlying the temple's first lawsuit, and that a version of the complaint had been proposed and rejected as an amended complaint. Well, the city moved to dismiss the complaint as barred by res judicata and for failure to state a claim. The city also moved for Rule 11 sanctions. On February 5th, the city moved for summary judgment on the temple's remaining promissory estoppel claim, and on February 9th, the temple objected to the magistrate judge's order regarding motion for leave to amend. They argued that it was legal error, but that it was now moot because the temple had filed a second lawsuit. Well, the district court was not amused, and on September 15th, it issued a combined order addressing both lawsuits. In the first lawsuit, the court affirmed the judge's order of January 26th. The court ruled the temple failed to demonstrate good cause to amend its pleading after the deadline, and that the temple's proposed amendments to the constitutional claims were futile. The court also granted summary judgment for the city on the temple's promissory estoppel claim. In the second lawsuit, the district court granted the city's motion to dismiss and its motion for sanctions. The court emphasized that rather than appeal the denial of the motion to amend, the temple filed a second frivolous lawsuit, and it wasted the resources of the party in the court. The city sought $33,000 in attorney's fees, and the court concluded that the temple's behavior, including its repeated disregard of court orders, suggests that a mere reprimand from the court would be insufficient. So they looked at the billing, they said a portion of the work was duplicative, and it ordered them to pay $16,000, which is roughly half of what they'd sought. The court emphasized that rather than appeal the denial of the motion to amend, the temple filed a second frivolous lawsuit, and it wasted the resources of the party in the court. The city sought $33,000 in attorney's fees, and the court concluded that the temple's behavior, including its repeated disregard of court orders, suggests that a mere reprimand from the court would be insufficient. So they looked at the billing, they said a portion of the work was duplicative, and it ordered them to pay $16,000, which is roughly half of what they'd sought. Keziah here appeals to the Eighth Circuit, saying the district court abused its discretion by imposing sanctions, failing to consider non-monetary sanctions, and granting an arbitrary amount of sanctions. Now we move to the standard of review. The standard of review here is going to be abuse of discretion. If it were de novo and the court were deciding this as if it were the one imposing the sanctions, then it would not have to give the trial court any deference whatsoever. But here, because it uses an abuse of discretion standard, there is almost no chance that he's going to be successful on this claim. Take note that they did not appeal the dismissal. So we review a district court's determinations concerning Rule 11 under an abuse of discretion standard. The fact is that Rule 11 involves fact-intensive close calls. As a result, they give deference to the trial court because it's on the front lines of litigation. And a district court only abuses its discretion if it bases its ruling on a clearly erroneous assessment of the evidence or an erroneous view of the law. Rule 11 sanctions are warranted when a pleading is presented for an improper purpose, such as to harass, cause delay, or needlessly increase the cost of litigation. And it also authorizes sanction if a pleading includes claims, defenses, and other legal contentions that are not warranted by existing law, a non-frivolous argument for extending, modifying, or reversing existing law, or a non-frivolous argument for establishing new law. A sanction imposed under Rule 11 has to be limited to what suffices to deter the conduct. The court first says, we agree the Temple's second lawsuit ran afoul of the rule against duplicative litigation because the Temple had no right to maintain two actions on the same subject in the same court against the same defendant at the same time. Like res judicata, the rule against duplicative litigation seeks to promote judicial economy and protect people from vexatious litigation. The analysis considers whether the parties to the action are the same, whether the claims arise from the same nucleus of operative fact. The test here is satisfied. Under the circumstances of this case, we disagree with Keziah's contention about the righteousness of the second lawsuit. The magistrate judge concluded the Temple failed to show good cause for an untimely motion, and basically requiring the Temple to bring all the claims in a timely manner doesn't constitute a denial of a full and fair opportunity to litigate them. Insofar as Keziah and Temple disagreed with the magistrate judge's ruling on the leave to amend, their recourse was to appeal to the district court and potentially to the Court of Appeals, not to start a new lawsuit. The district court properly criticized the Temple's efforts to use duplicative complaints to evade the magistrate judge's ruling or expand its procedural rights. A court's determination that a proposed amendment to a complaint would be futile operates as a ruling on the merits of the proposed claims, and as a result, they simply could not refile them in a second lawsuit. They'd been barred by res judicata. The magistrate judge also told the litigants that the city would be prejudiced by if the temple were permitted to file a second lawsuit. It did it anyway. And he says, look, even if a monetary sanction was justified, the court erred in awarding fees. And that's because insurance covered the attorney's fees. So the city didn't incur the fees. And the court said, look, you're focusing on the word incurred, but Rule 11 permits a sanction and other expenses directly resulting from the violation. And that's what happened here. Even if the city's insurance carrier ultimately paid the fees were incurred for the motion and could be awarded under Rule 11. Keziah next argues the district court abused its discretion by ordering sanctions without a detailed explanation to support the amount of sanctions, and that didn't go anywhere either. In deciding the amount to award, the court determined based on its experience that the rates charged by the city's attorneys were reasonable and far below prevailing market rates in the district. According due deference to the district court based on its familiarity with the litigation, Eighth Circuit saw no abuse of discretion in the court's conclusion of that award of $16,943.40. For the foregoing reasons, the order of the district court is affirmed. I remember worrying in law school that if I advanced a novel legal theory or made a suggestion that a case was, improperly decided, then I might get hit with Rule 11 sanctions. And that doesn't really appear to be the purpose of the rule. It's not there to keep lawyers from coming up with new and inventive ways to plead cases. What it's there to do is protect the rights and the sort of the legitimacy of the system. You can't let somebody just abuse the rules and get away with it. And unfortunately, there are people who want to do that. I might even say that in the context of federal litigation, there are some lawyers who are more like sovereign citizens than they are like civil litigators. And that is that they really don't think the law belongs or applies to them. They wind up doing things they later wish they had not. I have seen Rule 11 sanctions come in fairly rarely. I do recall in a case recently, about 3 years ago, we were litigating against Ford. Ford withheld bunches of documents that they were supposed to turn over in the course of discovery, and they got hit with a fairly significant sanction under the rules. Then as soon as that check was written, the court dismissed our case, and we lost. It's possible to win the battle and still lose the war. At this time during the year, what my Aunt Naomi used to call the dog days of summer, it gets very, very hot, and a lot of the elderly either don't have air conditioning or don't use air conditioning. If you have neighbors in your neighborhood who are experiencing heat stress and that sort of thing, and please check in on them because it has been brutal. It was 102 degrees here yesterday on the thermometer, which meant that the feel of the temperature out there with about 75% humidity was somewhere around bake on the oven dial. So kindness is never repaid, it's only passed on, and I'd appreciate it if you would pass some on. Thanks so much for watching. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.